Hey everybody, this is attorney Jason McGrath. How are you today? We're going to talk about judgments and whether they can be negotiated. I'm a lawyer who practices in North Carolina, Florida, and Tennessee, primarily in North Carolina these days. My firm's headquartered here in Charlotte. We also have an office in Charleston, South Carolina, and practice in a number of states. I've been a litigator pretty much my entire career, starting back in 1996 when I was the prosecutor for 5 years. And I've been involved in all kinds of civil lawsuits and other types of cases. And one of the questions that I hear posed quite frequently is, I have a judgment against me, what the heck can I do? Am I just totally out of luck or what? Or can I negotiate? Or I guess I just give up now or what? And look, the answer is that negotiations can pretty much always occur. And compromises can pretty much always be reached if the parties involved are willing to reach a compromise. It's fairly rare, not impossible, but it's fairly rare that a court or a legal authority is actually going to step in the way of two private parties. I'm not talking about government cases and things like that, private parties. The courts are not usually going to step in and say, well, no, we're not going to let you settle the case that way, unless what you're trying to do is illegal or so out of bounds compared to what's acceptable in our society. But let's just say, purely hypothetical, that you are in a post-foreclosure situation, whether it's commercial or residential. In fact, I'll talk about a case I recently had, obviously anonymously and to protect confidentiality, but there was a big bank that may or may not be headquartered in part here in Charlotte, that had foreclosed on a commercial office building that my clients had owned. And there were, a number of underlying controversial issues during the foreclosure and the alleged default on the loan, that kind of thing. I was not involved in the case back then. The bottom line is that negotiations fell apart, a foreclosure occurred, there was a foreclosure sale of this commercial office building, and then post-foreclosure, the big bank filed a lawsuit against my clients attempting to collect the monies that the big bank claimed to still be owed. And we're talking, at the end of the day, they were seeking over $1 million. And so the clients ended up hiring me to take over from previous counsel, basically saying, hey, look, is there something you can do with this? We've got a judgment against us. They're seeking all this money. We don't have it. We're never going to have it. The company's essentially bankrupt. We don't have it personally, that sort of thing. And, I told them what I'll tell you is that I can never guarantee anything, and compromises take, work from both sides. But, whether it's a post-foreclosure pursuit of a deficiency judgment, as we call it, or there's already a deficiency judgment or other kind of monetary judgment in place, you can still go to the other side and try and negotiate. Now, you're going to have to motivate the other side. And if you owe them $1 million and you want to pay them $10,000, it's probably not going to work. But if you have some money you can pay, and more money you can pay over time, and the creditor, the plaintiff, the bank, whomever, has enough information to believe that settling the case, giving up some of the money they think they're actually entitled to, is a reasonable and good business decision, they usually will do it. It may take some time, there's no guarantees, you're going to have to probably provide personal financial information to the other side. You don't really want to have to do that, but if you want something from them, they're going to require you to give information that allows them to make an informed decision. But if you have a judgment against you or somebody is seeking a judgment against you, it's rare, almost never is the right answer just to give up. So yes, you can negotiate it. Yes, judgments can be satisfied or even sometimes reversed, vacated, undone if the parties so agree. So don't give up, explore your options, and it typically makes sense to at least consult with a well-qualified lawyer to see what your options might be. Good luck.